Justice M.A.A. Abume, who read the judgment on behalf of the three-man panel of justices, held that the application filed by the third respondent, the Independent National Electoral Commission, on the power of the tribunal to grant petitioners relief to count ballot papers not tendered and was admitted in oral application was properly made and needed not to be admitted again in evidence. The Court of Appeal said that the ballot papers need not to be admitted as the tribunal had earlier admitted it as oral application, which was proper. It held that by virtue of Section 41, subsection 10 of the Electoral Act, the petition lacks merit and dismissed it. On the application on recounting ballot papers used in Akoko Edo, Ego, Esako East and West local government areas in the 2016 Edo State governorship election, another member of the three-man panel of justices, Justice Mudashiru Oniyangi, ruled that the tribunal was right when it refused to continue counting of ballot papers used in Akoko Edo, Ego, Esako East and West local government areas in the election after the 14-day allotted period by the petitioners to prove its case. Justice Oniyangi dismissed the application for lacking in merit and also struck out a cross-appeal filed by the third respondent. Counsel reacts to the appeal court judgment.
The court has made very important pronouncement and far-reaching decision on the steps taken at the lower tribunal with respect to recount of ballot papers we produced before it. The Court of Appeal has held firmly that the lower tribunal was right to have ordered recount of the ballot papers without the ballot papers being first tendered and admitted in evidence.
The issue of extended time for them to continue with the recount has been dismissed. The main appeal has been dismissed, and we are very grateful to God.
The implication is that parties are still as they were. The ballot recount wasn't completed, nothing was tendered in proof of the recount ordered by the tribunal. So we are still where we were as at the time the tribunal stopped the recount exercise.
The appellate court is expected to make available copies of the judgment to parties from Tuesday, 11th April 2017. Kingsley Uchebu reporting.